Okay, thank you all of you. I want to brief to all of you about the ruling of the Supreme Court just recently on the 2nd of this December 2024. I think we all knows that both criminal cases and civil cases among the tribal trial and appeal should be done here in the district court as per paragraph 4 and paragraph 5 of the 6th schedule. And the government through the governor from time to time used to issue the notification empowering the judge, the magistrate, to deal with the criminal cases and civil cases. And I think we all know that during the recent few years, one person named Komarchan has been accused and passed the order by the district session court Nongpo, convicted him as the accused on the cases. These cases is among the tribal. Commercial, he appealed this as the aggrieved person. He appealed to this High Court. During commercial cases, he raised the issue that the decision or the judgment of the district session court is not valid because it is not dealt in the district council court. Because case among tribal should dealt in the district council court. Why in Nongpo court, the district session court? I think you remember during that time, even the government get some confused. The High Court put one question: what is the jurisdiction of the district session court in terms of CRPC and CPC? I think you remember the government is busy, the whole law department, how to notify so that it will produce in the High Court. For that cases, the government notified saying that criminal cases and civil cases can be dealt in the district session court. But paragraph 4 and 5 shall continue. It is not very specific. The point is, how will we continue if it is given empowered to the district session court? The High Court, based on that notification of the government, in this commercial, uphold the decision taken by the Ribohoy district session court. Right from 2023, no single cases has been filed in the district council court because the order of the division bench in paragraph 34 of the order of the division bench saying that notification 2015 and 2018 that empower the magistrate and the district council court is superseded by that notification of the government just recently. If that is the case, the district council court has no more power to deal with the criminal cases and civil cases. All concerned parties file cases directly to the district session court. And the district session court did not refer anymore to the district council court because of that order, that all this notification has been superseded by the latest notification. And the Meghalaya Judicial Service Rule 2006 stand. That is the reason that all our court in district council no single case has been received. I think we have to close all the dismissal court because of this judgment given by the division bench. We have no way out. If we lost the judiciary, slowly we lost the legislative, we will lose the executive, unknowingly. So we have no way out. We have to appeal in the Supreme Court. But yes, it is very complicated from one point of view. Because here the aggrieved party is commercial. He, as the aggrieved party, should appeal in the Supreme Court. That is the normal procedure. But when we read 34 paragraph and 38 paragraph, we are the victim. We are no more empowered to deal with these criminal cases and civil cases. So we also are the victim. Some lawyer, they advise, no, you ask commercial to go, no. Commercial, how will we have no idea with commercial. Our only main purpose is to protect the dismissal court. So we send our assistant legal advisor, few advocates to Delhi to discuss with Hansaria, the very senior most Supreme Court lawyer, especially a specialized Supreme Court lawyers. Then only one hearing on the 2nd of December 2024, the Supreme Court stay, not the whole order, stay the paragraph 34 and paragraph 38 of the said order. We do not intervene with commercial. That is different issue. But our counsel has been protected. But this is, it has been stayed. We will continue hearing the case, but we are very happy that only one hearing. We have been convinced because of our provisional of the Constitution in the paragraph 4 and 5. So why I said that this is the landmark for us? Because without empowering the District Council Court, then it is very difficult for the judiciary to survive. But in fact, this is not new for District Council. I think you all know. In 2014-15, if I am not wrong, when the High Court give the order that no Rangabashnong can functioning, when we move Supreme Court, it stays the order of the High Court. It is very clear that District Council provisions are very strong and they are protected for us. Maybe someone say that no need for civil, but when we see in many cases we face in the Supreme Court, I think we have to agree with me that we need very much for the civil. Because in we, the Khasi people, we say that both Bishar and Sinshar, mean judiciary and executive, should be with us. If we lost Bishar or what we lost judiciary, how will we deal with many cases which have been as per practice, custom, tradition of the Khasi people? But this is very important for us. So it seems that in the district we have very strong provision to protect our people, our land. But what we need is to do some homework. It seems that even in the boundary dispute that had been could not bring to solution for many years, time has come that as the district council, along with constitutional experts and advocates, should be discussed. We start discussing on this issue. Because boundary of the state, Meghalaya and Assam, the genesis is the paragraph 20 of the 63. When you look at Northeast Assam Reorganization Act 1969, they reflect about that the boundary is as per that Khasi state. In Northeast Reorganization Act 1972 also, the justification is as per the paragraph 20 Khasi state. But now very sad, maximum of the area of the Khasi state has been under Assam, which is against the purview of the different notification, different acts. If the Hima Khairim could prove with evidence and proof that we still exercise our